Hello, I'm Yvonne Lau from the HHS Office for Human Research Protections, and I'm going to talk about broad consent in the revised Common Rule that was published on January 19th, 2017. So under the revised Common Rule, there is now a new term and a new option called broad consent. This option provides another way to facilitate the conduct of minimal risk research. The rationale behind creating this category is that it would allow subjects a means to exercise their autonomy to allow secondary research use of their identifiable materials for future unspecified research. I said that broad consent is a new option provided under the revised Common Rule. In the pre-2018 Common Rule, the term broad consent does not actually exist. This may be strange to some of you, since in the research community, we understand that a number of you have been referring to the type of standard informed consent where you provide information that describes a broader future secondary research use. So the question is broad consent allowable under the pre-2018 Common Rule? I venture to provide you with this very gentle yes response. Yes, only if the consent, the information that is provided in this standard consent, meets the requirements under Section 46.116A and B in the pre-2018 rule, that the requirements are described and there's enough specificity included for this future research use. And the idea, therefore, is that the more general the information that is included in this standard consent, the less likely it is to satisfy all the requirements that are needed to satisfy Section 46.116A and B in the pre-2018 rule. So for the rest of this talk, I'm going to concentrate on this new option with this term broad consent that is being described in the revised Common Rule. All right, as I've said, it's a new option for doing secondary research. And the focus here is the word option. Nobody needs to use it. There are many existing options for doing secondary research that remain, even within the context of the revised Common Rule. And in fact, many of the existing options have been expanded. And these include, for example, using materials with identifiers removed, using the expanded Exemption 4. So under the pre-2018 rule, Exemption 4 has two provisions, possible provisions that people can use. But in the revised Common Rule, there are now 4 possible options within Exemption 4 that people can look at. Then also the option of getting IRB waiver of informed consent continues to exist, or otherwise going back and getting subjects to provide a standard informed consent that meets the requirements described in 46.116. All these options continue to exist for secondary research, and as I've said, some of them have even been expanded, providing more opportunities. So for many researchers, using the existing options may be preferable to using broad consent for future secondary research use. If investigators are contemplating on using broad consent under the revised Common Rule, there are a few things that one needs to remember. It is a permissible option only for secondary research, and that refers to research use of identifiable private information or identifiable biospecimens that are collected for either research studies other than the one that is being proposed. So in other words, they've been collected through other kind of research projects unrelated to the current secondary research proposal, or these are materials that are collected for non-research purposes, such as, materials that are left over from routine clinical diagnosis or treatments, information that are collected through other channels for other use, other purposes. And so all that kind of information and biospecimens, if they're being reused in a research study, then we can refer to these as secondary research use. In other words, broad consent use does not apply to other types of research, and the typical ones would be those that one goes out to interact and intervene with subjects and collect their data biospecimens for the purpose of that particular research. We call that type of research primary research. In terms of the use of broad consent, we anticipate that it would be useful to facilitate storage, maintenance, and future secondary research when details of such future research may not yet be available. In other words, since this kind of information, this kind of details are not available, it'd be hard to use the standard 116 type of informed consent. So primarily, we anticipate broad consent to be used to qualify for use with the new exemptions that are provided in the revised common rule, and I'm referring to exemptions 7 and 8 here. But that's not the only way that we can use broad consent. It can simply be used for just any other non-exempt research studies, non-exempt because of the use of identifiable materials, identifiable information and identifiable biospecimens, and researchers may find that this is a way to promote autonomy of the use of such identifiable materials from individuals. We envision that broad consent for future secondary use may be obtained at the time when standard informed consent is obtained at the original or initial primary research, when investigators are interacting and intervening with subjects under a clinical trial situation, for example. So at that particular moment, when they're getting the standard informed consent to do that particular type of, primary research, investigators who already plan ahead and think that, this material that we are collecting through this primary research, we might want to reuse it for future secondary research, but because we are unable to, have a clear concept of what this secondary research may be in the future, but it would be useful at this point in time to actually also obtain the broad consent from the subjects to ask for their permission to have these materials for this broad type of future use. So this is time perhaps to do it. Or broad consent we also envision that it may be used or requested at the time in a non-research setting. So when, for example, hospitals, clinics where they look after patients, they come in for a clinical diagnosis and treatment. At that time, the hospital and clinics may think, well, you know what, there's all this, material that we collect for the medical record purpose and through the diagnosis and treatment, biospecimens that may come out of that, and all that information and materials that are biospecimens that are remained after diagnosis and treatment, if we can ask people to provide their broad consent for their future use, that would also be a very good way of contributing to science. So those are the two, time frame, if you like, that we envision that people may be asking subjects, potential subjects or individuals for their broad consent. Now, notice that if broad consent is requested, all the elements that are described for broad consent under the section 116D in the revised common rule must be included. None of the elements can be waived, all right? There are further limitations to the use of broad consent that I need to talk to you about. If individuals were asked and refused to provide broad consent, the IRB cannot waive informed consent to the use of the subject's identifiable private information or identifiable biospecimens in a secondary study that falls within the scope of the research described in the broad consent. So this is an important point to remember. However, do note that the use of the materials, when their identifiers are stripped, continues to be allowed. As many of you realize, that is not human subjects research, and that falls outside the scope of the common rule. Now, the restriction to access identifiable materials in case, in the situations where if investigators anticipate that a certain number of individuals, when presented with the broad consent, might refuse and decline to provide that, and that may cause the situation where a group of the materials from a group of individuals may become unavailable to be used for research that requires, secondary research that requires the use of identifiers. So if that is the case, all right, this sort of restriction may limit the value of the research and may cause researchers to choose not to seek broad consent altogether and may consider using other ways, other options that are available for secondary research with identifiable materials. So there are more limitations to the use of broad consent that investigators need to know. Use of broad consent will require tracking of the affected information or biospecimens. As I've explained, if a subject is asked to provide broad consent and they refused and declined to provide that consent, that information needs to be conveyed to the IRB in the future, because IRB needs to know that they cannot waive consent for the use of the identifiable materials from these subjects who have declined to provide broad consent. So tracking is required for both the yes and no responses. And one could imagine that there may be logistical difficulties as well as cost implication for this kind of tracking. And these kind of difficulties we anticipate potentially may limit the use and the popularity for the use of broad consent. So now I'm going to switch gear a bit and go and talk about some of the details related to broad consent. So broad consent under the revised rule includes some required elements that we see and we're used to in the standard informed consent. They are now, under the revised common rule, they will be found in section 116B. All right, these are reasonably foreseeable risks, potential benefits to subjects or others, confidentiality safeguards, and participation is voluntary and may be discontinued without penalty. So these 4 elements, required elements in the standard informed consent, are also included in the broad consent. And there are also additional elements in the standard informed consent that are also included in the broad consent. And these are, when appropriate, a statement about commercial profit and whether subjects will or will not share in it, as well as, when appropriate, whether research might include whole genome sequencing. So these additional elements are also included in broad consent. Now, there are elements unique to broad consent, and in the revised common rule, they're found in section 116D. There needs to be a general description of the types of research that may be done with sufficient information that a reasonable person would expect the consent would allow. So while it can be broad, while we can, this form of this option would allow a broad description, but we still expect that the description would provide subjects a good enough idea of what type of research they could expect would be covered in this consent. There needs to be a description of the identifiable materials that might be used, whether there might be sharing, and if there will be sharing, with what types of institutions or researchers. There needs to be a description of the period of time the materials may be stored, maintained, or used. Information on who to contact about subjects' rights, storage and use of materials, and research-related harm. As applicable, a statement that subjects will not be informed of specific studies and that these may include research that they might object to. And as applicable, a statement that clinically relevant research results may not be disclosed to the subject. So these are all the elements that are either required or as appropriate that they are required to be included in the broad consent that is described under the revised common rule. And just a reminder again that IRB is not allowed to waive these elements. So that brings me to the end of this presentation. You notice that I've mentioned terms like secondary research in this presentation. There is actually another webinar on secondary research under the revised common rule, and I would sincerely advise that viewers also consider reviewing the webinars on secondary research. That would help with understanding the information that has been provided in this presentation. So please refer to the text of the revised common rule available on OHRP's website for a complete and accurate description of the regulatory requirements. And for this particular presentation, please review the regulations at sections 46.104 that talks about exemptions, and also 46.116A to D that talks about informed consent and broad consent. And if you have questions related to our rules, please submit them via email to ohrp@hhs.gov. And do check out the OHRP website at www.hhs.gov/OHRP for resources on the revised common rule. And so I thank you for your attention today.